Ready, mate? We're rolling? Rolling. Okay, mate. Well, first of all, congratulations.
Thank you.
Unbelievable result. I think it was very much expected, though.
Yeah, we felt we finished strongly. Hearing that took place in early July. There's a real belief that we'd got it over the line, and having been in the Court of Appeal before, you do kind of act on instinct and a little bit of sixth sense when you see the judge is nodding along. And our barrister, Robert Weir, KC, was making his submissions. It was a momentum shift.
Yeah.
I think at one point in my notes I just wrote game over. So
really?
And I was looking back over that not too long ago, just to kind of remind myself as to how I felt at the time. And I saw that phrase and I thought, yeah, I thought we did it. So when we got the judgment in, not surprised that we'd won, but really surprised as to how emphatic it was. It's an astonishing piece of work from the Court of Appeal. Unanimous decision. So all three judges have put their name to it. Can often be the case where one judge will write the lead judgment, and then you see at the very end, the other two judges will say, I agree, and I also agree. Here, it was very much we when they gave the judgment. So it's fantastic news.
Yeah, brilliant.
I'm taking it in.
So at what point, obviously, it was a 3-day trial.
Yeah.
I suppose let's kick off. Let's start with sort of how did we get here? You know, the Johnson case has not been something that just magically appeared in the Court of Appeal. You know, Mr. Johnson, yeah, I know he's been your client for a while now. Let's talk us through it. What physically happened at the magistrate's court? What did the judge ultimately not agree with that caused you to appeal and ultimately take it all the way to the Court of Appeal? If you just pull the mic a bit closer as well, because I think we're getting some outside noise as well.
So the hearing in the county court took place in November 2022. It was over 2 days, and we lost on everything. We lost on fiduciary duty.
2022, it was notoriously hard for motor finance claims in the courts, in the magistrates' courts. They didn't have a clue, really, did they? They were drawing a lot of comparisons to PPI and Plevin. It was
very, very tough. The commissions weren't as high as what was considered to be unfair in Plevin, and lenders and their solicitors would draw that obvious distinction. And we found that a lot of courts at county court level were not interested in the nuanced points we were trying to make about fiduciary duty, disinterested duty, the fact that this, the paperwork that the lenders and dealers were relying on buried the reference to commission. It was never explicitly stated that a commission would be paid. It was always, we may receive a commission, or as a possibility. And we thought at the county court stage we would at least get home on unfairness, and we didn't. As I say, we lost on everything. So we made the decision to appeal with Mr. Johnson's instructions. That then took place in 2023. Middle of 23, we had a appeal hearing before His Honour Judge Jarman KC. We actually did win that appeal, but the question of unfairness got remitted, which means it's basically sent back to the county court. And we were not happy with that decision. We thought we could be in a never-ending circle of losing in the county court, appealing in the county court to a circuit judge, and then get sent back. So we just made the decision to appeal that decision to the Court of Appeal. We got permission early January 2024. There's a bit of delay with getting Mr. Johnson's case, his application for permission approved. But as luck would have it, in retrospect, it allowed the other two cases which are featured in the judgment, the Wrench decision and the Hopcroft decision, to come up alongside the Johnson decision. And all three of them got permission to appeal earlier this year. And then the Court of Appeal, fully cognizant of the fact that this was an important area of law, they expedited the appeal hearing. And as I say, we had it in early July, I think the 2nd, until the 5th of July, right in the middle of election week.
Yeah, unbelievable.
There's a lot going on.
And did you ever one point when you physically knew that you was going to appeal the Johnson case, did you ever think it was going to be so significant to not just the motor finance industry, but like every single industry that pays commissions that aren't not necessarily disclosed to the consumer?
I didn't, Sam. No, I'll be honest with you. I was just focused on my small area of law,
Yeah.
if you like, and I was just hoping that we got a breakthrough because, as you've said, it was so hard at county court level to get consistency across the judiciary with decisions. You'd have one decision one week and you think, right, that's a judge who sees how these cases should be dealt with, and then the next day you'd lose spectacularly.
And just going back to 2022, it was a really new area. The claim type was really new. For people who were in the trenches, you know, yourself at HD Law, you know, Sentinel Legal, we did quite a lot, and we was uncovering a lot of problems in the lack of disclosure. You know, when we was getting the disclosure, it was heavily redacted. You know, taking that to court, and then more importantly, educating the barristers that were advocating on behalf of the client. It was quite hard to really sit down with barristers who were really, really busy at the time. Obviously, they was doing still quite a lot of plevin and other work, to educate them on the actual level of lender tactics, lender behaviors, the way that they've physically gone around the houses to obscure the data, to not provide the necessary data to physically say, wow, these commissions are not just large, but they are fully undisclosed.
Yeah.
Did you find that it was quite hard to get people on side to support the initial idea of taking it to appeal?
Yeah, obviously, present company excluded. You were fully on board, and quite simply couldn't have done the appeal without Sentinel helping out. But yeah, there was a lack of belief in certain quarters as to what was really going on. I know you'd done some really good work. You were speaking to people in the industry and really, I'm probably going to use a number of puns, but lifted the bonnet upon what was really going on at dealership level. But it's also symptomatic of the small claims track is that the rules of disclosure are not the same as they are with a fast track or a multi-track case. There's no standard disclosure obligations. So to some extent, lenders do have the opportunity to be economical, shall we say, with the disclosure they give. And Sentinel did great work in uncovering what was going on, particularly, I think it was with Black Horse, the way they would dress up these commissions, and, you know, it was a bit semantic
and
gymnastics.
I think that's one of the things that a lot of people don't realise who are sort of on the outside looking into the space, the level of, you know, literally blood, sweat and tears from certain law firms, certain lawyers in particular, yourself being one of them, that has gone not just to one county court claim, but to an allocation hearing, you know, educating the judges on what has actually gone on here to make sure that they don't treat it like a PPI in a plevin case. Then you wait for the judge to decide whether they're going to keep it on small track or give it its appropriate time on fast track, which is definitely what these cases need from the complexity perspective. But there's been a million barriers in the way that's ultimately got you all the way to the Court of Appeal.
It has, yeah.
So I just wanted to kind of set the tone for people, really, because what I'm very conscious of, that there's a lack of understanding regarding what has actually happened in motor finance mis-selling, and how it's ultimately arrived to where it is, and how big of a deal this is to the average consumer who ultimately, you know, needs a car to get to work, take the kids to school, go to you know, Sainsbury's or wherever. You know, the case of Mr. Johnson, and we'll just use Mr. Johnson's case for the rest of this podcast, is just talk us through, like, Mr. Johnson, you know, what he did for work, you know, who he was. You know, he was your typical blue collar worker. He needed a car. He didn't have the funds to pay.
Yeah,
just talk us through that.
You're spot on, Sam. He was your classic example of somebody who's working class, doesn't have the funds to buy a car up front. So they need finance. He was a factory supervisor. He just passed his driving test. It was his first purchase.
Wow.
And the dealer saw him coming because the loan that they brokered for him with Firstrand Bank Motor Nova still wasn't enough. He needed a top-up loan, which, when you take a step back, is a bit squiffy. But so he needed a loan for part of the price, and then he needed a second loan. And he was under the impression it was Trade Centre Wales, that they were acting in his best interests, and that they got him the best deal, and that they'd gone to a panel of lenders and got the most suitable lender, and all that was not true.
Yeah.
Dealer was being completely dishonest. And Mr. Johnson's one of a million people. you can look at the circumstances of Wrench and Hobcraft as well. It's featured in the judgment. They're all ordinary people who, like you say, need a car or a vehicle to get around, don't have the money to pay for the car up front, need this finance. And then what you have is a dealer or credit broker, as the Court of Appeal have quite properly defined them, being in this advantageous position where they have your financial information, your need for finance, and then you're at the dealer's whim and they say, right, we will get you the best deal. And like most people, when they go into a car showroom, they want the car. They're under a bit of pressure to come out with the car, and they're trusting that dealer to get them the best deal and not to be making a second form of profit, which is what the commission is. All three claimants in this case thought the profit the dealer made was on the sale of the car.
Yeah, and that I think that's an important point. You really can't overlook the mindset of the individual, the consumer, that when they're going into a car dealership, they're very much expecting that dealer, that salesperson on the sales floor at the time who's giving you the information on the car, they are selling one product, and that one product is the vehicle, not a finance product. And I think there's a lot of stuff in the actual judgment that I've read that goes, and I agree with it completely, in the sense that when you go to buy a vehicle, you are trusting that car salesman to go, what's the value of the vehicle? Is it fair? Okay, I can't afford it. I want to pay monthly. I want to get some sort of finance, and they're going to shop around to provide you with the means to buy that vehicle. And I think one of the things that was really interesting about this case is that not so much that there was a clear breach of that trust between the dealer and the client, but the car price was actually valued as per the Glasses guide, which for everyone watching is an industry standard guide of what this vehicle is worth. It was actually being sold for almost £1,600 above that Glasses guide. And that's £1,600, which Mr. Johnson couldn't get finance on because Motornovo Firstrand Bank would only fund 100% of the value according to that guide price, which I think was 4,700, 4,800.
Yeah.
They required Mr. Johnson to go out and get a personal loan to top up that £1,600, so he could pay the ticket price that Trade Centre Wales was charging, which was £6,499.
Correct. Yeah.
And that additional personal loan, 100% of it was to fund the commission element.
Yeah, the commission element was 1,600, and the personal loan was 1,595. So give or take.
Give or take.
Yeah,
that's unbelievable.
Yeah,
and I think when you're sat and I've done the exact same. I've had many cars on finance, and I imagine yourself as and most people use finance to buy cars now because who's got that sort of money lying around, but you're never at one stage in the vehicle buying process looking at that guy on the other side of the sales counter, expecting him or any chance at all of him ripping you off to that level of extent.
No, I've spoken to so many clients, particularly when taking witness statements, and the general consensus that they are helping you. They're trying to get you a good deal.
Yeah. They're selling a car. They're not nothing else.
Anyone who's bought a car, there is a very pally-wally attitude of a car dealer.
Yeah.
I'm not saying that they're like Boise or David, but it's that kind of,
It's a nice process.
It's I'll sort you out. Correct. What are you looking for? How can I help?
How much do you want to pay?
Yeah. What's your budget? And like you say, that the idea that they're getting a backhanded second payment as commission for either putting themselves as a preferential lender, without there being any panel selection, or in really egregious cases, setting the APR so they can get more commission.
Yeah,
that's probably come on to that a bit later, but that's known as a discretionary charge agreement. It is abhorrent, and the Court of Appeal have zoned in right on this practice and gone, no. I mean, there's some of the language they use in the decision is it doesn't hold back. They use like selfish, dishonest.
Exactly. Well, I think that kind of ties in to where I want to go with it next, just to really illustrate the point, is that the Trade Centre Wales commission was £1,650.95, and that actually equated to 70% of their overall cost of finance.
Yeah.
And you was in PPI since the day. You've done a lot of plevin. 70% of the cost of finance was commission going to the Trade Centre Wales. Like, how does that happen?
Because it was allowed to. They were keeping it secret. There seems to be this conflation between commissions and dealers saying commissions aren't bad. They're not. There's nothing wrong with commissions. Just don't keep them secret. Be upfront with your customer. Allow the customer to make a decision. And in Mr. Johnson's case, he could have quickly worked it out and gone, well, this second loan's just funding your commission. I'll go elsewhere. I'll get a loan. In fact, I don't want the car. It's about being in a position to make a choice as a consumer. There's nothing wrong with commissions per se. It's the keeping them secret and burying reference to them in vague terminology on page 7 of 8.
Would you say that the whole concealment of it and the fact that they buried it in the terms and conditions and they never pointed out to the client is almost like an admission of guilt? Like, they know that if he was to ever be aware of that, he would never agree to it, so we're not going to bring it to your attention.
They'll never say, but you can join the dots.
Yeah.
It was the same.
It's almost like looks like shame.
Yeah, there was reminds me of a phrase in the Court of Appeal decision in Potter, which was a PPI case centred on limitation, and it was to do with deliberate concealment. And there's a passage from Lord Justice Mayles, as he was then, where he basically says that the banks were doing this for a reason, and it was commercial, and it was a decision was made at a high level not to tell customers. And it's the same attitude by the banks, is in tuck it away, bury it. Hopefully they won't see it. Hopefully they won't ask any questions. The dealer makes money. We make more money. Jobs are good, and we move on to the next customer. So, yeah, I think they'd never admit it, but there's a definite motive for the vague reference, we may receive a commission. And as the Court of Appeal said, it's buried and kept out of plain sight. Yeah.
And I think what's really interesting is that when we've taken quite a lot of these cases to court, some of the judges, some of the more ill-informed judges, because just simply they've not seen enough of these cases, they fail to recognise the implications of the commission element on the individual, and when we've had to break it down to a lot of these magistrates, judges, these DDJs, and especially in Mr. Johnson's case, that commission element equated to about 12.5% of his annual salary.
Yeah.
The overall car purchase was almost 50% of Mr. Johnson's annual salary. So when you have the defence that are trying to say that, these commissions are insignificant, they're small track claims, the commission isn't enough, it's not that high, what's the problem? It might not be high from a person's individual financial perspective, but when you look at the vast majority, and I'm speaking on Sentinel's behalf here, when you look at the vast majority of Sentinel's clients, a lot of these commission elements and the cost of finance equates to a significant portion of their monthly disposable cash.
Yeah.
And I don't think I've not seen any of our clients anyway, where you could say that if I reduced your monthly premium by £100 or £150 in some cases, whatever that commission was split over the year, I could probably either shave a year off your term, or I could probably significantly reduce your monthly premium. And these people might have £500-600 disposable at best.
Yeah.
It makes a significant difference to the average consumer.
Oh, it's a massive difference. In Johnson, the commission represented 25% of their overall finance, and the Court of Appeal, I'll quote it, say that they consider 25% very high. So in a similar way to they did with Plevin, where the commission was 74%, they're not setting a benchmark, but they're giving an indication as to the levels of commission in a PCP, motor finance, mis-selling context as to what's high, and 25% is labelled as very high. So, as I say, the Court of Appeal is speaking to your point, is that these commissions can't be watered down or diluted and say, well, it only represents a small amount of the overall finance. 25% in a PPI context isn't high, but here it's classed as very high. The Court of Appeal as well have also, quite rightly, in my opinion, identified that it's the commission that the customer ultimately pays back through their interest repayments. There's this notion that you'll have seen it often in defences and witness statements from lenders where they say the claimant or the customer didn't pay for the commission. The commission was paid by the lender to the dealer, which is true up front.
Yeah.
But the lender then recoups that commission payment through the interest payments.
Through the interest payments, exactly.
Yeah, and again, the Court of Appeal decision so fruitful in its impact that they say, this is paragraph 161, if anyone's interested, in effect, the dealer is obliged to place the business with the lender, however uncompetitive that may be, and in return is entitled to a very large commission, which would ultimately be paid by Mr. Johnson. So that, again, is something I've been saying for years, trying to get across a county court level, and it's not always had the most success, but here we have the Court of Appeal, and I feel vindicated, I'll not lie, saying that take a step back and look at this transaction as a whole. Who pays for the commission ultimately? The customer. It doesn't come out of the lender's Christmas fund or loose change box. No, it's paid. Mr. Johnson paid it.
Yeah,
and he paid it through his interest payments.
Mm-hmm. Well, we've seen it one step further, as I'm sure you've seen it. I think I've shared this information with you that we've seen advanced commissions paid in the millions of pounds to some of these bigger dealerships. So if the consumer's not paying it, why is the lender paying an advanced commission based on sales, projected sales?
Yeah,
So it's, and this is one of the things that we've spent a long time educating, is that it's not just one commission, and I think it goes into it in the Johnson. There was an element of a fixed commission, and then there was a revenue share on the difference in interest.
Yeah,
just explain that.
I've heard of being called volume bonus. I think it's similar to profit share in PPI, but like you say, it's a global upfront payment to the dealer by the lender, and the lender saying, we know we're going to make significant profit through you selling our loan agreements for the purchases of the car. We're prepared to bankroll you because we know we'll make it back as profit. That's a disbursement they're happy to pay out. And like you say, ultimately, it's the customers who pay. Now, that's getting into more complex calculations, but nevertheless, it's real, it's there, and it's classified as commission, and it should be returned to the customers. Yeah,
and I think that literally just proves the whole point of why the discretionary commission model should have been banned years and years and years ago, not just in 2001, but if you're a salesman,
2021.
Yeah, if you're a salesman, and ultimately you've got this car to sell where you'll make a profit, we can understand that, but the lender is physically putting in a mechanism with the revenue share from the interest, where if you sell me at the highest point of interest, you're going to get a bigger slice of that pie, which is additional profit for you. Of course, you're then not impartial. You don't have a disinterested duty.
Correct. Yeah.
To find me the best deal. And I think when you start to strip it down, you start to understand those different elements. You start to understand just how big, widespread, how wrong this entire car finance industry has been, in terms of it just looks black and white, set up to rip off the average Joe punter who's coming in to buy a car for whatever reason they need to buy one.
I couldn't have put it better myself, to be honest. It's exactly that. You hit upon the test that the Court of Appeal hammered home. It is a disinterested duty. It's not necessarily a fiduciary duty that's important. It's a duty to be impartial and act in the best interest of your principal, who in this context is the customer. But they don't. They feather their own nest, and they do the deal that gives them the most profit with the lender. Yeah. And the customer foots the bill.
And I think that brings us on really nicely to the whole lack of understanding of how car dealerships work, and how they've now been engineered by the finance companies to be essentially finance. The vehicle is now the mechanism to sell the finance, for these car dealerships. And I think one of the things I really wanted to talk about is the lack of understanding from customers. And we touched on it briefly, we'll go into a bit more detail, in the sense that customers are not aware of the relationship between the finance house and the dealership. And what they're not aware of is that all of these retail rates and terms agreement, these dealership business terms, that physically prohibit the dealership from shopping around, from finding something that physically is the best deal for you, even though in most of the terms and conditions it says that we will approach our panel of lenders to find a really good deal. In the case of Mr. Johnson, Firstrand, Motonovo, they couldn't go anywhere. The dealership physically had to give Motonova Firstrand first refusal.
Correct, yeah.
And that's where they got the most commission.
Yeah.
So when they've said that, and I think it says it somewhere within the judgment in terms of what the actual wording was, but it says that they would shop around, they would approach the panel of lenders, they would find the best deal, and the Court of Appeal have come out and used something that was just an absolute lie. And if I'll find the exact bits, but don't you think that's just a complete lack of understanding that's being preyed on by the lenders to how the customers think that purchasing a car dealership works?
Yeah, some customers or clients I've spoke to think it's all in-house. It's that much of a...
Yeah, they're completely uncorrelated.
Yeah, they've got no... there could have been another lender.
Yeah.
I thought it was all done in-house. No, something's in-house. There shouldn't be commissions going backwards and forwards. But yeah, it was the suitability document, I think, what you were alluding to was the... they were going to purvey a panel of lenders and get Mr. Johnson the best deal, and that was just simply not true. And as I say, the Court of Appeal didn't hold back in its criticism of Firstrand's actions and Trade Centre Wales's actions in how they dealt with Mr. Johnson.
Yeah, no, I completely agree, and we'll find that section, but it's really interesting in terms of where the Johnson or the Court of Appeal case went, in the sense that there's been a lot of talk around the discretionary interest models, how they're now banned, whether fixed commission models are acceptable, and we at Sentinel haven't been running those ones. But what I think is really important about this is it doesn't really go into the commission model that much. It agrees that the commission model was wrong, but it's more about the unfair relationship argument and the fiduciary duty and the uninterested role. Can you just explain to us why that is such a significant? It's much more important than the commission models. And I think once you explain how the lenders put the dealers in such a conflicted position, it makes so much sense as to why the lenders are ultimately on the hook for this, and they should be paying out for it.
Yeah, the DCA model is putting the cart before the horse. If you focused on that, what the Court of Appeal have done is saying commissions, no matter what the model, in a context such as this, if they are kept secret or reference to its payments hidden, then the disinterested duty is breached, and the relationship is certainly unfair. If you then go further and look at the commission model itself, and it happens to be a DCA, DIC model, then it's even worse, because it's even more egregious, even more unfair, and you have a more of a nailed-on case, in my opinion. The Court of Appeal also, quite rightly, in my opinion, said that it was lenders who bear responsibility for this process. Although it was brokers who actions were doing it, there's something called accessory liability, which is covered under the Consumer Credit Act, because all these agreements fall under that particular statute. And they reaffirmed that it's the lender who bears the liability and the responsibility to ensure that the customer knows about these commissions and knows that they're being paid and knows the amount and know what impact that has on the finance. And the reality is virtually all lenders were not doing this. And the cat's out of the bag, really. They can't go back in time. And the other thing to also consider is all the terms and conditions, from what I've seen, what you've seen, probably you've seen more than I have, are all written in the same terminology. So again,
small print,
the die is cast, it's buried in the small print, and that's Court of Appeal language. And it's not brought to the customer's attention.
Yeah,
and it's designed to be hidden. It's the same. I don't know if it's a good example, but when you come to the end of an advert and the advert's selling you this thing nice, and at the very end, somebody starts speaking at 100 miles an hour, and you're thinking, hang on, slow down. It's all, it's that kind of, and off you go, off you pop, and the customer doesn't know what they've signed up to also has strings attached.
Yeah.
And they're just interested in getting a car at an affordable price. Like you say, they've got a monthly budget in mind. They go in there, they think I can afford to spend X for this car. And the amount of times I've heard clients say, well, for example, I had a budget of £150, and then you look at the agreements, it's 189. Yeah. And they just push them, and you think that's probably the commission every month, the £39 extra is just financing this commission, this second form of profit.
Just the increase in interest, isn't it? Well, I think it's one of the biggest ones everyone seems to have had is that the lenders have hid for a long time behind that wording of we may pay a commission, or a commission may be paid. And the Court of Appeal goes into that terminology, and they say that, well, if it may have been paid, then you know how it was calculated, what the methodology was, what type of commission model it was, whether it's like the RSA, whether it's fixed, whether it's DIC, So why they didn't go into that in further detail in the terms and conditions, we may pay a commission and it might be modelled on this, or it will be modelled on this. But I think what's really interesting in when I've read the entire judgment is that the Court of Appeal points out something glaringly obvious, and I'd never really considered this before, is the sense that the lender makes it physically impossible for the dealer to uphold, to be impartial, to have a fiduciary duty because of the terms of business that the lender makes the dealer sign up to. And if the lender makes the dealer give them first refusal and gives them a higher commission for doing so, or maybe even an advanced commission or multiple different commissions, however the deal's structured, obviously the Court of Appeal drew a lot of attention to these dealer terms of business and how critical they are to the actual claim type. How could the lenders not check to see if the commission was being disclosed and to what extent it was being disclosed to ensure that the commission is disclosed, so they're absconded from the whole fiduciary duty uninterested parties? Again,
this was touched on in the Court of Appeal. The lender has a relationship with the customer. They say, here's our loan documentation. They could have told the customer straight away. This idea that they're that's so far removed from this transaction, it was the broker. You've got a relationship with the customer, a direct one, because you start to take their loan repayments. You could have written to them and said, before you sign this agreement, please be aware, we pay your dealer a commission of, in Mr. Johnson's case, £1,650, I think it was, as a financial incentive for that trade centre placing the finance with us.
Yeah.
Do you wish to proceed? They could have done that and they would have been completely in the clear, but they don't. But there's a phrase, sunlight's the best form of disinfectant, and they didn't bother to speak to Mr. Johnson. They didn't bring the payment of the commission to his attention. They gave the impression that there was this panel of lenders when there wasn't. It was
clearly wrong.
It was Firstrand had first refusal. And it's a stitch up. Mr. Johnson's the one, like you say, has to take out this second loan, which equates to the commission payment, and he pays interest on the repayments towards that element of the loan. And he's someone who's just passed his test and wants a car on finance. He's 27 at the time. He's a factory worker. Things are hard enough, and you don't need your lender and your dealer stitching you up like that when you come into them innocently saying, can you help me? I need help buying this car. You're at their mercy. Here's my details. Can you get me a good financial deal? I just want to buy a car and, like you say, get to work or drive around. Particularly when you passed your test, you're dying to drive around and get the bus anymore.
That's the first thing you want to do, yeah.
Yeah, and when you look back in hindsight, they saw him coming and they did a number on him. And the Court of Appeal, I think they get this. My experience, I've been to the Court of Appeal 5 times, and please say every time I've won. But what comes across, and all my cases have been about consumer protection mainly, is the higher up you go, the more the likes of the Court of Appeal understand the consumer needs protection. And that's what the Consumer Credit Act was designed to do. And this is what the disinterested duty, it's protect the little guy and not allow big businesses to ride roughshod over them with unscrupulous practices or not being clear or burying. I keep saying that word, but it is what it is.
Yeah,
They buried the information. It was a cover up, and it's for me. It's my best win in the Court of Appeal.
Yeah,
it's a delight to read. I've read it about 4 times, and with each reading, it just gets better because it ticks all the boxes. It's what we've been saying for the last 2 years.
Yeah, it's unbelievable to see the Court of Appeal use words like selfish and dishonest, but that's exactly what it is.
Deceived.
Deceived. Whatever word you want to call it.
Yeah.
But it was 100% lenders acting in their greed interests, being dishonest, taking advantage of unsuspecting consumers coming in, assuming that car salesman earns his money from selling a car, which I think every single person probably listening to this right now, everyone I've spoken to would assume that's how car dealerships make their money, not from having exclusive relationships with the finance houses that are going to pay them a commission, not just for securing the finance, but securing the finance on as higher interest rate as the lender would allow them to.
Yeah, it's exactly, again, it's what we've been discussing for the last 2 years, and it just feels like we've been heard at the highest level. And it's worth mentioning as well that it's probably common knowledge, or anyone who knows this area and has been following the lenders in this particular case will seek permission to appeal, I understand, and the Court of Appeal have been quite emphatic, saying that they don't think permission should be granted because they've been so fulsome and so detailed and so emphatic in their judgment that they're essentially saying this isn't the case which the Supreme Court should consider. Now, it remains to be seen what the Supreme Court will do, and I have no idea. But again, that's something I've not seen in my experience. And I've been doing Consumer Credit Act, consumer type work for the last 15 years. I've never seen the Court of Appeal go further and say, there's a postscript in the judgment, and I invite people to read it, and that gives the temperature or the mood at which the Court of Appeal are in, having heard the 3 different circumstances of these 3, the normal people, and like you said, they've been stitched up with this practice, this lender, dealer, behind the scenes, backhanded, whatever phrase you want to use, commission. So it's a fantastic win for the consumer. It really is, and it feels really good that the Court of Appeal are reaching out to the consumer and giving this judgment and giving such clarity, and they know that it will be looked at. They know the county court will be looking at it, and it's great that the county court have got some clear guidance, because that's been needed, in my opinion. The FCA now have clear guidance as well, because they're going to face having to deal with a lot of complaints, because consumer awareness will be raised, hopefully, because a lot of people will be affected by this. A lot of people who bought cars on finance. If you bought a car on finance and it was through a car dealer, there's a high chance you've got a claim, in my opinion.
Yeah. I just want to come back to what you said about the Court of Appeal and the judgment in terms of the postscript. I mean, I've never read one with a full Q&A on the back of it, a question and answer section on the back of it, that, in my opinion, across all of the cases that we've ever litigated on, we have lost a case for one of those multiple reasons that have been brought up in the Q&A.
Same.
And do you think that the Court of Appeal have physically structured this postscript, this Q&A ending of the judgment, to learn lessons from what happened in PPI and Plevin and the way that was dragged out for so long, and it was escalated and it went up to the Supreme Court and so on? You know, the consumer ultimately was sat waiting and waiting and waiting to ultimately get the redress, and obviously the redress came and it was great, and I think it equated to about 3% of GDP at one time in its heyday. But do you think this is the Court of Appeal basically giving the nod to everyone to say, we have learned lessons from PPI and Plevin, and we are going to make sure that we have got crystal clear answers, so that when these are being handled by the lower courts and the magistrates' courts and so on, there is not a stone left unturned in terms of how these cases will be interpreted moving forward?
It would appear that way, yeah. You don't know for sure, but I've never seen this in a Court of Appeal judgment. But I agree with you. I think it's designed to give crystal clear guidance to the county courts and the claims industry as a whole to know where everyone stands and not leave things vague. Like you say, it took the Supreme Court to hand down its decision in Plevin to finally get that clarity. I would say that this decision is clearer than Plevin as to the scope and the detail it goes into. Plevin was quite straightforward in the sense that it was just to do with unfair relationships and large commissions not being disclosed. But I agree, the Court of Appeal, I think they say at the outset, they say this is a test case, or let me just see what the phrase is. It's at the interim. Three appeals which concern a common situation. They don't perhaps go as far as to say this is a test case, but in reality, that's what it is. It's three different cases with slight nuances.
Yeah, different commission models.
Exactly. And the Court of Appeal know that people are, everyone's going to look to the decision. So they've come out with all guns blazing. This question and answer and the postscript, it belts and braces, in my opinion, is to say, if you are in doubt, having read the judgment, I think it runs to some 80-odd pages, here's a question and answer. A quick nutshell's guide as to what, if you're in doubt, after reading 80 pages of our judgment, here's that. and if you're in doubt as to whether this type of situation should be appealed, we say no. I mean, I think the final paragraph, we hope our analysis will provide sufficient guidance for the county court judges who have to deal with these types of claims on a virtually daily basis. Now, there may be a situation where the issue of fiduciary duties is revisited, but I think what the Court of Appeal is saying here, and it's only my opinion, that not in this context. In this context, it's quite definitive. It's so imbalanced and so much of a disadvantage suffered by the consumer that what they're recommending is not in this context. Fiduciary duty is a broad area of law. It doesn't just cover motor finance or consumer protection. There can be fiduciary duties between two commercial entities, and in that context, it might be appropriate for there to be another case, but that case will be distinguished from the case of Johnson. I think they have known that all eyes are on them for this area of law, and that they've got to come in with a fulsome judgment. That's why I think it's unanimous. Yeah, all three judges have put their name to it, and I'm really pleased that they've done that, and I'm delighted with the decision. And again, the Court of Appeal have got it right, and they tend to do with consumer protection. They're very consistent, and that they seem to understand that consumers need the protection of the law, and they've come in with bells on with this, and they've really set it down. And the other elements, and it's not my case, it was the Hobcraft and Wrench cases, but they went further and said that it was fully secret, and they talked about rescission, and you can have an agreement unwound. So it's not just about getting the commission back. In certain circumstances, you can have a refund of all sums paid towards the car. You can have, if the car's or the agreement's still live, you can have the remainder written off, rescinded, subject to issues of counter restitution, which I'm not going to today. Yeah. But they've covered all bases in terms of remedy, in terms of the law, in terms of any potential appeal. Like you said, the question and answer session is a kind of a snapshot as to what the case is about.
Yeah, exactly. Well, I think with Sentinel, you probably agree. We've done a lot of these cases in the magistrates' courts, over 500 cases that we've litigated so far, and it very much was roll the dice. It's a lottery on the day, what court you was in, what area of the country, what judge you got, what advocate you had on your side. And I think up until January the 11th, when the FCA came out and said that there's a redress scheme likely and it's coming, and we're going to do more. We're going to announce more on the 25th of September, which obviously they've further pushed back. But even then, after the FCA coming out saying we had almost certainly going to offer some form of redress, it was still very much a lottery. And I think that was just down to the lack of overall direction, the lack of clarity from the higher courts, because it just didn't exist. Yeah. There was different ones like Wood and Herstanger and so on that gave some form of clarity. but there was nothing in relation to motor finance because it was such a more complex way in the way that the lenders remunerated these dealers. And I think there's a couple of interesting bits, and I think for anyone watching, if you're not going to read all of the pages of the judgments, which I don't blame them, it really took my best ever over the weekend.
They're
but
not as anal as me and you.
No, but the question and answers is really black and white. It leaves nothing. There's a section here, and we've got pushback on this quite a lot in Sentinel. Is that it says, does a statement in the terms and conditions of the credit agreement that commission may or will be paid have the effect of negating secrecy? And the Court of Appeals responds, the very last part of the answer just says, burying such a statement in the small print, which the lender knows the borrower is highly unlikely to read, will not suffice.
Yeah.
You can't misinterpret that.
No,
can't misinterpret it at all. And I think the way they've structured this answer and questions is in such a layman's way that you don't need any form of legal training to understand this. It is not subject to interpretation. It is very black and white, cut and dry.
Yeah.
Did the broker owe the relevant duty to the claimants in these cases? Very simple. It's a very simple question. Yes, in all three cases.
Yes, full stop.
Full stop.
And then they go on to elaborate, but it's...
Yeah, it is still a yes in all three cases. And I think, I take my hat off to them in the way that they've done this, because I think, like you said, that the lenders would have ultimately tried to appeal. They've put a stop to that. Take it to the Supreme Court.
Yeah.
Keep it open to interpretation. And they've done as much as they physically can here to make it as cut and dry, across the industry. Like you say, just not just motor finance, but anywhere where there is a commission paid that is not properly disclosed to the consumer, whether that's motor finance, insurance, aviation finance, whatever.
Yeah.
There's a fiduciary duty.
Yeah. In a consumer context, like you say, it's cut and dried. There's the other part as well, the bit I like in it, because it applies to Mr. Johnson. Was the relationship between Mr. Johnson and Firstrand unfair for the purposes of Section 148C of the Consumer Credit Act? Yes. Mm-hmm. No explanation.
No.
Yes. Full stop. Game over. It is in a consumer context involving finance or the provision of credit. It's as clear cut as they could have made it. I couldn't have written this judgment, but I couldn't have wished for a more clear cut judgment. And like you say, the other thing as well is it is a complex area, and I have a lot of sympathy for the district judges who, if they're not familiar with this type of case, must be bamboozled by the sheer, the authorities that were being relied on. Like you correctly say, they weren't on point in a motor finance selling context.
Yeah.
Wood wasn't, Herstanger wasn't. They were germane to the issues, but they were not on all fours. And the Court of Appeal know what they've given your county court judge is a quick overview, guidance, saying, look, it's almost saying we will help you out. Here's the answer.
Yeah.
And what that should do, one would hope, is feedback to lenders and their solicitors and say, do we really want to run this to trial?
Yeah, exactly.
Who knows what they will do, but hopefully there will be some form of pressure applied to lenders, and they should engage in ADR and not burden the courts. They're already oversubscribed the courts, and not burden them with pushing the cases to trial. Ideal scenario would be there's an inward looking soul searching from the lenders, as if to say, okay, the game's up. We need to start making payments to our customers. That would be the ideal scenario. We don't know whether that will happen, but it's clear that the Court of Appeal have very much had the district judge who deals with these day in, day out in mind, and gone, we're going to help you. We're going to try and break it down for you. So when you do if any of these cases do get to trial, they can pick up this judgment. They can go to page 79 and it's there. It's paragraph 173, and they can get a quick overview.
Yeah, well, it felt very much to me when I was reading that sort of conclusion and disposal section that they were either aware of the questions that were coming from the county courts, or they'd canvassed the county courts in between sort of the conclusion of the trial and submission of handed down of this judgment, because every single element we've been pushed back on multiple times, and it's always been up to us to argue the toss, and it's made that job as easy as possible. But I think there's a specific section within the judgment that is about record keeping, and you've probably had it as much as us. One of the things that we always come back to is we're constantly asking for the retail rates and terms agreement, which is essentially the dealer's terms of business, what the relationship was between the dealer and the lender, how the commission model was structured, what would qualify for a payment, what the floor of the interest rate could be, what the ceiling of the interest rate could be. Pretty much everything that you would ever want to know from a law firm's perspective in terms of submitting a claim is contained within this documentation.
Yeah.
And the Court of Appeal quite rightly say within the judgment that they were shocked that these documents were never pointed out to the trial judge at the time. And we've had it a number of times where, and I think it was in it was either Hopcraft or Wrench, where they actually said the documents didn't exist, but they could use a similar one at a similar time to suggest what the commission model was. What do you think is, let me rephrase that. Given the importance of these documents,
Mm-hmm.
and I think I've shared a number of the ones that we've had with Sentinel where they've been so heavily redacted, they say they don't have them, they've clearly obscured sort of certain elements of the documents where you physically can't interpret them. Sentinel's had the response a number of times from lenders where they say these documents are of no material significance to the claim.
Yeah.
What do you think the refusal for disclosing of these documents is going to be from the lenders, if any, at the minute? Because we're still getting pushback despite the judgment.
I think they'd be hard pushed now with this decision to say, it's not of a material benefit, because you just hit them round the head with this decision.
Yeah,
and
it's
say,
clearly
it's
been
clear.
said. It's clear.
Yeah, the documentation should be disclosed. It shouldn't be redacted, because it goes towards important information that needs to be understood to establish what duties were breached and whether the relationship's unfair.
Yeah.
So I think it's a new world now when we're asking for these documents. They should be disclosed. They should have been disclosed prior to this judgment. But
Correct.
with this judgment coming out, it's nailed on, I think.
And then one of my concerns of the lack of sort of record keeping, and when they come back and say we don't have this documentation or it's of no material significance. I know you speak directly with the FCA and you're speaking with the Ombudsman as well. What do you think the significance of these documents and the relationship between the lenders and the regulators, the lenders and FOS, in terms of being open and transparent post this judgment, is going to have on a potential redress scheme? Because my concern is that they would treat the regulator and the FOS like they treat us, the law firms. They're not going to give us everything unless you know what to ask and you explicitly ask for it.
I don't know. With PPI, once the redress scheme, PS 17.3, was set up, there were many lenders who were quite open in the sense that they admitted what the commission was and they did the calculation. So I think in some instances, I wonder whether the lenders adhere to what the FCA and the FOS say more than the courts, because when that redress scheme was set down for PPI, there were a lot of lenders who did admit what the commission was, did the calculation, did everything in line with the policy statement 17.3, because they were compelled to do so if they dealt with a complaint. So it might be the case that if the FCA, for example, set down another policy statement for PCP, you may find lenders getting in line with the FCA statement and disclosing what they need to. There is a hope that they finally see that the game's up with this decision and they stop being silly and they start to work towards fair compensation, because that's all the customer wants when they instruct Sentinel or HD Law. That's all they're after is, have I got a claim? Yes. What am I entitled to?
Correct.
You tell them, and you go to the lender and say, well, this is the claim. You need to disclose these documents. Hopefully this decision makes it, you've
Black
got to now, come on, Before this, you could dance around it, and often defendants do, and they don't disclose information. But I think now, with this decision, they'd have to. But I think if the FCA do, and I'm sure they will come up with a redress scheme to deal with the complaints, I probably would see lenders just following it because they think, fine, like, you know, we'll employ staff. And I think, for example, Bank of Scotland or Lloyds used to disclose the levels of commission for PPI post 2017, was when you'd ask that information pre, they'd sit on it, they wouldn't tell you. So there was a bit of a sea change.
Yeah. Well, my concern was we was approached by the FCA back in March, and we provided them with a number of documents, including quite a number of the retail rates and terms documents. And we went through the exercise of showing them how we receive these documents, heavily redacted, you know, back to front, misaligned, and so on. You know, the usual tactics that the lenders do. And when we was actually screen sharing the data room with them and talking them through what they're actually looking at, because they didn't know, you know, that I genuinely think that people who have been put in charge with the redress scheme of this investigation, they genuinely didn't know. Maybe the regulator as a whole did, but the people I was speaking to didn't. And they came out with and this is the exact quote: she couldn't believe what she was seeing. And my concern was that if I'm showing you something that you didn't know exist, you're probably going to fall over the trap that Sentinel Legal fell right at the start, and probably yourself. We approached the lenders and said, can you show us the commissions? Can you evidence the level of commission that was paid on this vehicle? And to which point they came back and said, yeah, it was £100, it was £150. That's what the salesperson on the floor who sold the car earned in the form of commission for the vehicle.
Yeah.
And it wasn't until you obviously went to court and you got a bit of disclosure ordered and you did a couple of pad-apps and so on, that you start to understand the correct terminology, and you was to ask, you know, what's the level of commission at a dealer level, you know, what the manager's getting and so on. And I thought there's a real concern that if the regulator doesn't know what questions to be asking, then the lenders can almost circumvent the question because you're not directly asking for something, so I'm not going to give it.
Yeah.
And I thought whenever the FCA is talking about a redress and the entire industry is saying what could a redress scheme look like, what could an average quantum look like in terms of what's the average claim value to the average person on the street who's got a car on finance, I was always concerned with what I've seen the level of lender behavior go to really hide the true extent of the remuneration.
Yeah.
That the FCA wouldn't know where to even begin looking. Like, have you got an opinion on that?
I think it has to be. I think we have to lead the FCA and the FOS. In my opinion, we're at the forefront. You know, we've been instrumental in getting this decision, along with consumer rights solicitors. For the consumer, we need to be telling the FCA and the FOS, no, this is what you need to be looking for, because they're not as experienced as you or I or other solicitors.
Yeah, we've been in the trenches.
Exactly. And I think we need to, with all due respect to the FCA, teaching them, no, this is what forms a case. The phrase commission needs to be extended, not just looked at narrowly, and lenders being cute with, well, when you say commission, it's all financial incentives.
Yeah, or any and all remuneration paid to the dealership.
Because the test is one of substance over form. You know, you can't label it commission and say, well, let's just, like, say it was the £100 to the guy who sold the car. Come on, that's not what we're talking about. It's not what the court of appeal are talking about. So I think there needs to be frequent dialogue and a working together between the professionals who are leading the charge, as we are, and the FCA, who need to listen to us and then think, well, how do we implement this? But they're not as experienced as us, because this is what we're doing day in, day out, and they've got other complaints to uphold, other things to look to. So I really hope that wouldn't happen, but I hope also the FCA and the FOS would listen to us and say, okay, why do you need this information? As I said, we've got this case now, so it's to see whether these duties are engaged, and they should disclose it. And if they do, then we know whether we've got a case or not. Yeah, it goes back to that phrase. It was introduced when civil procedure rules first came in 1999. Litigation should be conducted with cards faced up on the table. It's not like it used to be, where they'd hide it and, you know, they'd be cute and litigation had gone for years. It's no, disclose what you've got, and let's get to the bottom of it. If you're in the wrong, let's deal with it and let's settle it and move on. You know, you've already breached the law. We'll find out. Yeah. don't be silly, you know.
Yeah.
And I think this, again, I keep going back to this decision, but this decision is our platform now to say the game's up. You know, it's obvious what you've been doing. It's a standard process. It's rolled out on an industrial basis. The Court of Appeal have admonished you, really, in how you've behaved. Let's come to the table and talk, and let's try and deal with each one of you. I mean, they're former customers as well of the lenders. They always seem to forget that. They're not just our clients. They were at once a former customer, and you'd think the lender would want to, you know, at least retain some reputation. Maybe not, I don't know.
You know, there's one thing that I've always thought about is the level of personal conflict on the opposition side. You know, the guys acting for the banks.
Yeah.
And, you know, car finance is a very, very common product. You know, we've all got it. Everyone's had a car in finance, or most people have had a car in finance, including probably the lawyers on the other side. You know, surely they're seeing this level of missell, the way that these consumers, including themselves, will have been taken advantage of. You know, if they're driving around in the nice Mercedes, the Audis and Range Rovers and so on, they've clearly been ripped off. It's, you know, it's very clear that has happened. Do you ever think the personal conflict element ever comes into the mind?
Well, having never been on the other side, I couldn't possibly say. I think they may do that, but they'll probably just take their client's instructions and, you know,
it's just a job.
It's they'll
probably submit a claim.
Yeah.
Keep it quiet.
Yeah. Should contact Sentinel.
Yeah, exactly. Or yourself.
But who knows? You know, you have chats outside court and you take, you know, the hat off, and they just happen to take instructions from their client, and they've got to do what's best for their client. So I understand, but possibly, I mean, they cannot read this decision and not see the writings on the wall.
No.
I think even the most ardent opponent and robust opponent must see the impact of this decision. But they have to take their client's instructions and do the best for them. So
So just going on to the Supreme Court element of things, you know, that's the burning question I think everyone's now got. You know, whether you're a funder in the space, whether you're a law firm in the space, you know, whether you're anyone with any remote interest in what's next for motor finance claims. The Court of Appeal have obviously set out their stall very clearly.
Correct.
Close Brothers have lost 34% of their share value since Friday.
Yeah.
You know, we're filming this on the Tuesday. The judgment came out on the Friday. Do you think the potential appeal of the Court of Appeal's judgment to go to the Supreme Court would be purely a marketing exercise from the lenders, given the postscript that they handed down in the actual order?
It could be. So they've got to apply to the Supreme Court for permission to appeal now. And I understand that they'll do that. It's something they can give to their shareholders and say, look, we're not taking this line down, we are fighting. So that might, in their mind, restore some confidence. And then if they do get permission, then they'll certainly try and say, well, we're challenging it. It's not conclusive. And we believe that the Court of Appeals got it wrong, and we plan to overturn that. But what they can't get away from in the meantime is that this is the law. This is what binds all courts underneath the Court of Appeal. And that's the world we'll be living in until the Supreme Court say otherwise. The Court of Appeal clearly think it's not in the interest of the Supreme Court to entertain this. I'd be surprised if they did get permission from the Supreme Court. I'd be astonished if they got it on the unfair relationship element,
that
because
would be shocking.
You know, the
Pretty
Court of Appeal see that as unimpeachable. They say yes, full stop, as we've said. But we'll just have to wait and see. It's a shot to nothing, really, seeking permission to appeal. I can understand why they've done it. I don't agree with it, but it makes sense from their point of view to do it. And we'll just see what the Supreme Court say. Yeah,
well, I think you said something really interesting there, and I think just for absolute clarity on that, from a layman's perspective, is that this is now binding in the lower courts.
Correct, yeah.
And what we've seen already since Friday, like I say, we're filming on Tuesday, we had a number of emails from various different lenders' representatives yesterday, asking for us to stay cases on the back of them ultimately appealing to the Supreme Court. We've had applications to vacate filed already. What do you think the strategy is behind that for anyone else who's seeing that? That this is binding in the court in the lower courts, as you say. It's very clear how these are ultimately going to end up. In my opinion, these are at 100% chance of success now, given what's going to happen.
Yeah.
What do you think they're trying to do?
I think they're trying to play for time. I think they're trying to protect their client's position, and I probably wouldn't say nothing's ever 100 in litigation, but I know what you mean. The prospects of success have dramatically increased. If I were to get an application like that, I don't think it's got any prospects in my view. The Court of Appeal have been clear.
Just
the
cheeky requests.
Yeah, whether they genuinely believe the substance of that application, they'd have to answer that. But I think they're just trying everything, and I think to put an application to stay a case that's ongoing, one that's perhaps heading to trial, and halt and deny that particular claimant justice. Justice delayed is justice denied, is one of the phrases we used to get taught at university. In this context, shouldn't be allowed, because the county court, who would be dealing with that application, in my opinion, say no. The Court of Appeal have been quite clear. Even if you did get permission to the Supreme Court, it doesn't act as a stay automatically. And if the other side don't want to stay, and clearly you wouldn't, because you would be wanting to go to trial with Johnson in your jacket pocket, then they should get on with it and allow cases to be dealt with and moved off. The county court shouldn't have all these cases backed up in the face of this clear Court of Appeal decision.
Yeah, exactly.
Even if they got permission to appeal to the Supreme Court, they should be allowed to continue. Shouldn't be stays imposed.
Yeah, well, we've got about 190 odd cases that are currently stayed pending the Johnson appeal, pending the Johnson judgment.
Yeah,
and that just for I know you'll know, everyone else listening will know that just to get through 195 cases in the county court is a feat in itself.
Oh yeah, these cases. I mean, I don't know how long they'll last post Johnson, but they were minimum 3 hours, sometimes a full day.
Yeah, full day.
It's a big task for the district judge to take on all the. It's very document heavy. The Court of Appeal say that a lot of these transactions took place a long time ago. So the crucial aspect of this type of claim is the documentation. It speaks to your point about redactions and getting the rate terms and suitability documents. It is a document-heavy area of law.
Yeah,
and it's not. You don't just zip through these cases.
No. I mean, the bundles alone are
authority bundles. I mean, hopefully the authorities bundles
one page,
just one case,
just the back answers.
Yeah.
But
the district judge has a lot to get through on these cases, and you say 190, that
195,
195. That's going to take.
Yes, if they all go to hearing, I mean, we're already getting hearing dates in sort of like autumn 2025.
Right.
So from an availability perspective in some of the courts, it is massively burdening the courts, and I think that's one thing that people who have issued maybe one or two cases don't really appreciate. But from a regulator perspective, from the way the Court of Appeal have handed this down, I think not only from a sort of crystal clear, this is how these cases need to be handled, but it's made it that crystal clear that it should, in theory, in my opinion, make the availability of the courts become wide open, because it's very, very clear how this is going to go down.
In my opinion, these should start settling without courts being troubled. I mean, they say again, paragraph 178, we hope that our analysis will provide sufficient guidance for the county court judges who have to deal with these types of claims on a virtually daily basis. They're saying, we know district judges are looking to us. Here's our case. Here's our question and answer. Hopefully that's enough for you. And I think it is. And hopefully lenders will, or some lenders will take heed of this judgment, its impact, and go, look, we need to be not pressing these cases all the way to trial, defending it. We're up against it with the law. We should be really settling these cases. We should be engaging in ADR. That's what ADR is there for, is to take the strain away from the courts, because they've got more important things to be dealing with. There's a lot of,
But also, what's your opinion in terms of every time they're playing for time, like you said, every single year that goes past, every single month, week, whatever,
Yeah.
from a statutory interest perspective, which we know is being awarded on all these cases,
Yeah.
they're just increasing the value of their claims that ultimately they're going to have to pay out.
Yeah.
You know, and if Johnson didn't happen and we listened to what the FCA said when they said they were going to come out in May 2025 with next steps on a redress, and that could go all the way to December 2025,
yeah.
you know, that's the equivalent of about 16% stat interest in a best case scenario, which, as you saw in the Johnson case, you know, it was a significant part of the redress being interest. So do you think that the lenders are ultimately shooting themselves in the foot by delaying paying out?
I don't know. It might be the case that possession's 9/10, and while they've got hold of this money, which they should really, in our view, hand over because they've behaved unfairly and breached duties, they've got it for 18 months, and you know
they can do what they want with
exactly.
it. Yeah.
And they might, you know, get inventive and churn that money. They're a commercial entity. They'll use that money, and
Yeah.
I think that's the. I don't think they're too concerned because the award of interest is discretionary, so it's not always guaranteed, and they'll know that, and they'll know that they'll argue for a lesser rate of interest, and despite what the Court of Appeal says, I mean, good luck to them if they do. But I think they're just playing for time. It's kick it down the road.
Yeah.
In my opinion, they're just. We don't want to be writing checks.
Full stop.
Well, full stop. But now, on loads of cases,
Yeah.
because like you say, the share price, from what you tell me about Close Brothers, is tanked.
Big time.
I heard that Motor Nova's
is down.
been affected. Yeah.
Yeah.
So it's real. This decision's had a real impact, and
Already, yeah.
I think Close Brothers have put a halt on writing finance.
Firstrand Bank have written to saying that they're not writing any more car finance at the moment. I think Close Brothers have definitely done it, and I think a couple of other lenders have done it as well. And I presume that's just they're aware of the documentation, and this is pretty damning in terms of what the documentation should say and what the dealers should be doing. So I presume it's a case to issue new documentation rather than pulling out of the market.
Yeah, and I think as well, I mean, we don't know for sure because we're not on the inside of these institutions, but hopefully it's indicative of them taking this decision very seriously, and hopefully that leads to dealing with these claims very seriously. And I keep saying it, but the courts really shouldn't be bothered with these types of claims now. Yeah. Now the law's clear. It should be a case of ADR, in my opinion, should be utilised and dealt with, and these cases should be settling outside of court.
So just going back to the Supreme Court element, just so we can close that off, in terms of the process then, from an appeal perspective, what does the lenders have to do now?
So I was on the other side of an appeal to the Supreme Court in Potter. I was the respondent, and Canada Square appealed. They have to make an application. They have to put grounds of appeal. Now, they've already done grounds of appeal to the Court of Appeal, and the Court of Appeal have knocked back the grounds of appeal on all three cases and said, we don't think this should be appealed to the Supreme Court. Supreme Court obviously have to deal with it themselves, but they will repeat, or they'll probably improve perhaps the grounds of appeal that got rejected at the Court of Appeal level, redo them to the Supreme Court, and then they'll just wait for the Supreme Court to say whether they've got permission or not. If the Supreme Court say permission refused, that's it. It's the end of the line.
Really?
Yeah.
And how long does it usually take to get a response from the Supreme Court?
A couple of months, maybe a month or two. Yeah, it's.
We're end of October now.
You'd hope before the end of the year, yeah.
And when will they have written to the Supreme Court?
Oh, you're testing me now, Ivan. I think
roughly.
Yeah, I think it's either 21 or 28 days.
21.
If it's a normal, if it's Court of Appeal, it's 21. I know that much. I've never appealed to the Supreme Court. I've only ever been on the other side and on Potter, but I think it's 28 days. They will take the full time because you want to get it right, and then it'd probably be in December. We'd know. But then it's got to be listed, and in my experience, you probably wouldn't have a Supreme Court here until this time next year.
Yeah.
So I think this decision is going to be on foot and binding for at least 12 to 18 months. And that's great news for the consumer, in my opinion.
Okay. That's really interesting, because I think that's a burning question in a lot of people's mind is, where does it go from here?
Yeah.
Are we going to see a PPI Plevin state of play where it gets dragged out for years and years and years, or has the Court of Appeal physically done everything they've done in the way that they've done and used the language that they've used to say this is going nowhere?
I think you're right. I think it's the latter. I think that the Court of Appeal know that these types of cases affect millions of people. And they've borne that in mind. And also, when the decision in Plevin was dealt with, it was appealing the decision that had gone the other way. Plevin had gone against the consumer on the issue of undisclosed commissions. So Plevin was correcting a previous decision. So the Court of Appeal got it wrong in Plevin, put simply. Here, we think the Court of Appeal have got it so right, and hopefully the Supreme Court agree with us and agree with the Court of Appeal. But the Supreme Court's the end of the line. So if permission's refused, that's the end of the line. If permission's granted, then there'll be a hearing probably some point towards the back end of 2025, and decision early 2026. And then that is it. Whatever the Supreme Court say, that's the law.
Yeah.
And
so this has been a huge part of your life, everyone's life, for the last 4 years especially. And I mean, I imagine the sort of emotions that have gone through in terms of this appeal, and going through the hearing, and then obviously waiting to find out. I know when I spoke to you after the actual hearing, you said you was fairly confident. Nothing was set in stone. Just talk us through sort of what actually happened on Friday when you was found out ultimately that you'd won.
Yeah, well, so I've slept better Thursday night. And you have dreams that you've won, and
because just to be clear, no one knew it was coming out on Friday. It just got handed down.
It was listed to come out on Friday, and then we were just awaiting. No one had the official judgment.
Yeah.
So we got that shortly after. Funny story. So everyone was waiting, and I was waiting at 10:30 for the Court of Appeal to put it on its website, and it got to like 11:15. I think of it. Refresh F5 on my laptop, and then I ended up emailing the Court of Appeal directly, because I was a solicitor on the case, and said, can I have a copy? And then they sent the copy, and they flicked through it really quickly and got confirmation that we'd won. Printed it off, and I've read it about 4 times since, page to page, and it's really good to read, because it has been tough. You know it, I know it, and consumer rights know, other solicitors have been in this boat, and to get vindication and affirmation as to what you've been thinking and what we've been discussing in dispatches or over a coffee is right, and we were always right. It's a relief more than anything. I probably still haven't taken it in, to be honest. It's still quite fresh.
Yeah.
But I'll keep reading it, and I'll still. It's got so much purchase reading it. You find another phrase, another quote.
Exactly.
I've highlighted up to the yim yams, as to all the phrases I like and the points I like. And you can see how you would quote that in a skeleton argument, or you refer to it in court. But it's still pinch yourself kind of feeling, because it's perhaps a bit trite, but we do act for the little guy. We are, in my opinion, on the right side of
totally
how
agree.
And they're just ordinary people. Mr. Johnson was a factory worker. Mr. Wrench was a postman. I think Miss Hobgrass was a nurse.
Yeah, student
nurse. And it's everyday people who've had money taken off them that they didn't know about, especially when times are tough at the moment. There's a cost of living crisis, and people could do with that money. They could do with, like, you talk about your monthly budgeting. They could do with a bit of extra money. It probably would have paid for, I don't know, a gym membership, and or they might have been able to buy a Sky package and whatever. I mean, they've
gone on decent holiday, and
decent holiday, or they could have put money towards something else, or could have decorated something. But it's not. It's gone into the deep pockets of brokers and lenders for no other reason than as you've alluded to, it must be greed. You don't need to make that much money. You're making money on the APR as a lender, and you're making money on the sale of car as a dealer. You don't need to be doing extra stuff to disturb or muddy the waters, or, you know, particularly with the discretionary models, ratcheting up the APR in line with how much more commission. I mean, that's as greedy as it gets in that context.
Yeah.
So it's great. And I spoke to Mr. Johnson. He's quite keen to know about the decision, and I spoke to him on Friday, and he was delighted. And he said something really poignant. He was saying, "I'm so happy my case can help so many people."
That was the question I was going to have. Do you think Mr. Johnson knows the significance of his win?
Yeah, I've told him,
100%.
You'll be famous. It'll be your name.
Talked about for years. And
yeah,
years and years.
along with the other two. But it might be his name because he's the lead case, or he was the case that got permission to appeal first. But he said that, and I thought, that's so spot on. That's what you have done, what you've done, and instructed me to appeal, and backing myself and the barrister who acted for him at the county court level, Jonathan Butters, and then he was then led by Robert Weir KC. Mr. Johnson was a superb client. He was instructed us to appeal. Was very interested in the results, and as I say, in my opinion, encapsulates what it's all about. His case helps the people who need it most.
Yeah,
they needed help when they were buying the car, and they didn't get it. But thankfully, the Court of Appeal have come to their aid, and they've allowed them now an opportunity, a real clear pathway to get compensation, and it's not before time.
Yeah, and it is literally millions and millions and millions of people. I think the FCA came out and said 75% of the cars on the road at the minute are on finance or have used some form of finance to purchase them.
Yeah.
You are talking about millions and millions of people who have been taken advantage of. And in the vast majority of cases, these aren't flash cars, they're not sports cars, they're not, stupid purchases. They are genuine means to take the kids to school, to go to the supermarket, to just live, a basic form of travel.
Yeah.
That has just been milked by the finance houses via the dealers for years and years and years. And I've said it a million times that I just don't think that people realise, especially in the county courts. We had one judge in particular, who I won't name, who said the British public shouldn't be so trusting of car salesmen. And I thought, that's such a disconnected thing to say in terms of how big of an impact this has on people's livelihood. And we spoke to a lot of people. It's the second biggest purchase people make, besides the car, besides the house. It's the second biggest purchase they make, but it's probably one of the most emotional purchases that people make. You move house, you find the house, you go on Rightmove and so on. But a car, you research it, you look, you go to the showroom 3 or 4 times. You get the term tire kickers.
Yeah,
they know everything about the car, and it's a purely emotional purchase. And to find out that you've been literally ripped off, misled, whatever, through buying this vehicle that you're so proud of, just think is disgusting, and I don't think it's talked about enough in the wider news, in the wider industry.
No, it's been hidden away, like the commissions.
I
was just looking at the car while you were talking. I was thinking, Mr. Johnson got a Suzuki. Mr. Wrench, he was a bit more flashy, got a TT.
TT in a 3 Series, wasn't it?
Yeah. I mean, I actually know nothing that much about cars, but you think of the feeling Mr. Johnson just passed his test.
Yeah.
Everyone who's driven knows that feeling when you passed your test. It's a red letter day in your life.
Yeah.
And you think I don't have to get the bus anymore, or the train. And he must imagine how he felt when he went into that showroom buying that car. He had his heart set on the Suzuki, and he's gone into Trade Centre Wales, elated, thinking, they're going to help me out. I've just passed my test, and they didn't, and the lender didn't, and that's, like you say, it's terrible. It's what a way to behave. And no doubt, I can't say for sure, but the Trade Centre Wales knew the desire and the excitement in Mr. John. They feel it.
100%. Yeah. The salesman at the end of the day.
Exactly.
And they were enabled. I don't and have never once blamed the dealerships or blamed the salesman, because they were given tools to sell something and they sold it.
Yeah.
You know, they were enabled by the lenders, and that's why everyone needs to remember it's not the salesman. You know, you tell a salesman to sell a cup, they're going to sell a cup. If you tell them they can sell it with finance and they'll get more money, they'll try and sell it with finance.
And they probably had personal commissions and targets set
100%,
that were driven by the lenders and the higher ups at these dealerships to tell their salesmen and saleswomen on the floor, push this and push that agreement.
Yeah.
And
Well,
it's similar to PPI, you know, it was done at a high level deliberately to maximise profit.
Mm-hmm. Well, we've seen it in the advanced commissions. If they didn't hit the KPIs, it was clawed back.
Right.
And they were doing everything they could to make sure that at the end of the year, end of the quarter, that no commission was clawed back from them.
Yeah.
So, you know.
Yeah.
So I suppose just to wrap things up then, in terms of the next steps and the wider implications of the Johnson ruling on the wider market, you know, just not just motor finance. What do you think is going to happen between sort of now, the end of the year, Q1 2025? What do you see happening next?
Firstly, we need to see whether the Supreme Court give permission. But even if they do, as I say, there's a period of 18 months where this decision binds. From my point of view, and perhaps your point of view, we should hopefully see a lot of these cases having a smoother pathway to compensation now. There shouldn't be robust defences, in my view, being seen all the way to a final hearing, because Johnson's clear. Remains to be seen what the FCA and FOS do. You mentioned, and it might be the case that they want to use the period in which they're considering the DCA model to tie in with the fixed model and not do anything until December next year. In my view, that would be very unfortunate and would be an unnecessary delay to consumers getting money back. The FCA should be facilitating compensation in a speedy and efficient way, in my view. But it also covers other areas of consumer finance. It's a wide range, far-reaching decision in that context, and any situation where you have a broker in finance and there's a consumer involved, I think you've got an angle here to say there's probably an undisclosed or secret commission, and the relationship's likely to be unfair, and there's duties, disinterested duty has been breached. So it's not just car finance. I think in a consumer context, this decision affects its other areas, and it remains to be seen how far the tentacles of this decision reach. But
it's going to be big.
It's going to be big, yeah. You go through all the forms of insurance, and when brokers were sold and brokers involved, it's huge. And the Court of Appeal knew that when they were given this decision, and they did it anyway, and they pulled no punches in terms of the impact they wanted this decision to have. And they knew it would affect other areas, and they've come in hard and heavy on the side of the consumer.
One last question.
Yeah.
And this is just a personal question. The entire motor finance claim process has evolved around the hidden commissions, and there's been a massive fixation on DCA commissions, the discretionary commission, where the dealer could set the interest rate to directly impact their commissions. Throughout the entire Johnson judgment, Wrench, Hopcraft, it seems to very much focus on the fiduciary duty element owed to the client and the disinterested role of that dealer. Would you say that there is a potential for this to unlock the entire motor finance market for a claim, and not just the agreements that had a discretionary interest model?
Yeah, the focus is commission per se, and then once you crack that open, you see, well, is it fixed or is it discretionary? If it's discretionary, then it's even more unfair.
Mm-hmm.
But what the decision is, I said it before, if you're focused on discretionary interest charges or DCA agreements, you're kind of putting the cart before the horse. The focus is there a commission model?
Mm-hmm.
And if there is, and it's not disclosed, and Johnson applies, then you've got a claim.
Yeah.
Then when you unpick and go, what type of commission model was it? If you've got a DCA model, and in my opinion, you've got a model that's so unfair and so bad for the consumer that you've got a stronger claim than if it's fixed. But even if you have a fixed claim, which is what fixed commission claims, which is what Wrench, Hopcroft and Johnson were, you equally have a good claim.
Yeah.
You still pass the post
Yeah.
in either scenario. So I think what Johnson's done is kind of set in motion the right analysis and the right structure and an approach. And you've got the matrix of a dealer, a broker who's also a car dealer but can be defined as a credit broker based on Johnson, and a client. And then if you have a disinterested duty that's breached, you have commissions that are kept secret or hidden, buried away, and you have a payment of a commission, then you have the grounds of a claim. But you need to know that that commission's been paid as well. That's important because, the Court of Appeal says it may is not the same as being told there is one.
Yeah, it's either secret or it's not.
Yeah. I could say I may have had a croissant this morning. You wouldn't know unless I told you.
Yeah, exactly.
I did, by the way. So it's addressing all the points you and I have talked to death over the last 2 years, putting in black and white and making it law. And I say I couldn't be more pleased. And I'm pleased for Mr. Johnson as well, because as I say, he was a superb client to act for.
Yeah.
But the impact of this decision, I can't say what it is yet because I think it's that big.
Yeah.
It's seismic. It's got the ripple effect and the shockwaves that this will extend throughout the industry, consumer protection, wherever there's a broker involved, and payments of commissions, and they're kept secret because they invariably are, because they don't want to reveal to the customer that they're getting more profit.
It was such a big one as well.
They want to get away.
Commission.
They want to get away with it. They want to, try and duck and dive. And I think the Court of Appeal said, no, enough now.
Yeah.
That's not what you should be doing with consumers who need your help when they're coming to you saying, can you help me get a car? Here's all my financial details. Can you act in my best interests? Because you've got my information. You're my agent.
I'm trusting you.
I'm trusting you, yeah. And what they're doing is going, no, we're not going to do that. But they don't tell them that, but they say, no, we're going to look after our own interests, feather our own nest, and do what's most profitable for us.
Yeah. Well,
and not tell you about it.
The Court of Appeal literally said it was self-interest, wasn't it? Greed.
Yeah, sounds selfish, yeah.
Yeah.
They don't hold back.
No, mate, you did an unbelievable job, and I think there's millions and millions of people who sort of need to buy you a pint, but you and the guys at CRS obviously nailed it. And
and as well, we were supported by Sentinel and a few other guys, and it was a real team effort. There's a real nice collegiate cohort atmosphere to this area law. We all share the same passion to act for clients and get them what they deserve back. Point to remember is that, if the lenders and the brokers hadn't have acted in this way, we wouldn't be in business in this way. We're just picking up the pieces.
Yeah.
And it was a real team effort. So the decision's for everyone, but like, as Mr. Johnson say, it helps so many people. That's the main thing. And if we can help those people, then all to the good.
100%. And I think that's one thing that the law firms, the claimant-focused law firms, seem to get a bad rap. But what a lot of people don't realize that it's those claimant-focused law firms, like those investigators in those firms that originally bring the claim type to the attention of the regulators. And I think there's certain individuals that we won't name on this podcast, but we all know who we're talking about, that seem to give claimant-focused law firms a hard time. And what they don't realize is that they would never have known about it if it wasn't for people like yourself, CRS, Sentinel, other law firms in the country that do this day in, day out, and that they're prepared to sort of wear the heart on the sleeve for years and years and years sometimes to get the justice that's needed for the consumer. And I think no one can discount, or no one should discount, the level of work that goes on behind the scenes just to get this into the headlines.
No, and as I say, we're on the right side, in my opinion. And
totally
those
agree.
people who shall remain nameless who have a sneery, snobby attitude, I bet if their auntie or their mum had a claim, they'd want Sentinel dealing with it.
Yeah.
They want HD Law or CRS, because we're tenacious and we fight for the little guy. And it's trite to say, but it's true. Yeah. And the Court of Appeal, in the 5 times I've been there, consumer matters have always come down on the side of the consumer. They've always come to the consumer's aid and fell down on that side. And that says to me that we are on the right side. And we need to keep doing what we're doing.
Yeah. Well, I think the way that you've gone about the whole investigation, the case, the claim, packaging it up, there's been so much attention to detail that when it's presented in that way, you just can't really disagree with it.
Yeah.
So, but no, I appreciate it, mate. Thank you very much.
No, it's been great to talk through it. And
no, I think it's much needed. I think there's a lot of people out there talking about it in terminology that is confusing and ambiguous. And I think when someone as straight talking as yourself comes on, I've said this to you many times, that you say it as it is, and you don't try to dress it up. It is very much needed for everyone that's looking at the space at the minute to go, well, what actually happened? And I think what everything you've said today has hit the nail on the head. It's been understandable, and I think you're probably one of the most approachable persons in the industry. So if I'm quite sure you're prepared to talk people's ears off in whatever questions they've got as well. So
absolutely. I want the message to get out to as many people as possible.
No, quite right.
If you are inclined to read the judgment, read it.
I recommend anyone reading it. It's unbelievable.
It might take you a few goes, but go through it. Start with the Q&A at the end, and then work backwards from that, and look at those phrases the Court of Appeal use, where they've not held back. They've used emotive, direct, consumer protective phrases, and that gives a real insight to the energy the Court of Appeal had when they were coming down on this unanimous decision, and how they wanted to send a message, not to the industry, but to the lower courts, to solicitors who are acting on both sides, send a real message and say, this is the answer, this is what we think, this is how you sort it out. And as I say, I don't think they could have done a better job. It's a fantastic decision, a fantastic judgment.
No, I totally agree, mate. Cheers.
Thanks.
I really, really want to press this button. I think it's an applause. Is it an applause? Is it doing anything?
No.
Yeah, can you hear that? That's the applause. We're all going to press that.
Yeah.
Okay.